Mr. Bandy, I'm not asking you to agree with those facts, but do you understand that's what the state's evidence would be if this case went to trial?
Yes, sir.
You still wish to plead no contest according to this agreement?
Yes, sir.
Are you satisfied with your attorney's services?
Yes.
A defendant facing multiple criminal cases walks into court and chooses to plead no contest instead of fighting the charges at trial. The judge carefully explains that this decision means he won't admit guilt, but the court can still convict him based on the evidence. But here's the question: when someone gives up their right to a jury trial like this, are they making the smartest legal move? Under Tennessee Rule of Criminal Procedure 11, courts must ensure a plea is voluntary and fully understood before accepting it.
All right, Judge, I represent Mr. Bandy in all of his cases. Plea sheet reflects all 4 cases, so I've used as much abbreviation as I possibly could. Effectively, this involves cases 19838 through 19842, with varying ranges of misdemeanors and felonies. Effectively, for 19839, he will be pleading to count 1, aggravated criminal trespass, a misdemeanor. It'll be 1129, suspended to supervised probation, stay away from victim. As far as 19840, he'll be pleading no contest to count 1, resisting arrest, a B misdemeanor, and count 2, evading arrest, a misdemeanor. That'll be 6 months on supervised probation and 1129, suspended to supervised probation, concurrent with 19839. In reference to 19841, he will be pleading to count 1, evading arrest of the D felony variety. That'll be 4 years suspended to supervised probation, also concurrent with 19839. And finally, in 19842, he'll be pleading to count 1, evading arrest, E felony version. That'll be 2 years suspended to supervised probation, concurrent with 19839. All other counts in all other cases will be dismissed, meaning 19838 is completely dismissed. He'll receive pretrial jail credits from 11/4/25 to 3/5/26.
All right, Mr. Bandy, raise your right hand. Let's have you placed under oath.
Yes, sir.
State your full name for the record.
Thomas Wayne Bandy, Jr.
Mr. Bandy, you're here on multiple indictments, multiple cases, and you've heard your lawyer go over what the agreement is disposing of those cases, in which you're going to be pleading to some and you're going to have some dismissed as a part of the agreement. But have you seen or been shown a copy of all those charges, talked them over with your lawyer, and you and Mr. Vaughn discussed the range of punishment you're facing as well as any possible defenses you might have?
Yes, sir.
Well, it's indicated that you want to enter a plea of no contest. Do you understand that simply means?
One of the most serious allegations in this case involves evading arrest while driving at extremely high speeds. Under Tennessee Code Section 39-16-603, evading arrest, fleeing from law enforcement in a vehicle can be charged as a felony. But if the defendant accepts probation instead of prison through a plea deal, does that mean justice was served, or was the punishment too lenient?
You're not going to admit you did anything, but you're not going to contest the state's evidence when they tell me what the evidence would be in each of these cases. And I will use their statement of evidence to find you guilty according to this agreement. Do you understand that?
Yes, sir.
Do you understand, however, that you have a right to plead not guilty to all charges and to have a speedy and public trial by jury?
Yes, sir.
Do you understand if you went to trial, you would have the right to have a lawyer and have one appointed, as I've done with a public defender?
Yes, sir.
Do you understand that if you went to trial, you would be presumed to be innocent until such time, if ever, the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
Do you understand? Speak up just a little. We're recording everything that's being said, and Mr. Brandon down here has got to take it down as well. Do you understand that if you went to trial, you and Mr. Vaughn could confront and cross-examine every witness the state called to testify, and you could bring in your own witnesses by using a subpoena?
Yes, sir.
Do you understand you would be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial?
Yes, sir.
Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by entering this plea, you're waiving your right to that trial and to an appeal? All I'm going to do is approve what your lawyer has worked out with the state. Do you understand that?
Yes, sir.
Do you understand that's going to result in a number of convictions, and those convictions are going to be on your record in the future to make more severe the punishment you will receive if you are ever again convicted of a crime?
Yes, sir.
Do you understand everything I've explained to you?
Yes, sir.
Do you want to waive your right to a trial according to this agreement by entering a plea of no contest?
Yes, sir.
Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
Do you understand I cannot accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty of these charges?
Yes, sir.
And I want you to listen to this. The state tells me what their evidence would be if this case went to trial. Mr. Willoughby?
Yes, sir. In document all of Mr. Bandy's cases.
Mr. Bandy, I'm not asking you to agree with those facts, but do you understand that's what the state's evidence would be if this case went to trial?
Yes, sir.
You still wish to plead no contest according to this agreement?
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir.
Do you feel like Mr. Bond has done a good job of representing you competently?
Yes, sir.
Mr. Bond, do you know of any reason he should not enter this plea?
No, I don't, Judge.
Anything further from the state?
No, sir.
Then Thomas Bandy in docket number 19839, upon your plea of no contest to count one, an amended charge of aggravated criminal trespass, I find you guilty, sentence you to 11 months and 29 days in a county jail that will be suspended to supervised probation. You are ordered to have no contact with the victim. In docket number 1940, count one, resisting arrest, a class B misdemeanor, you're found guilty, sentenced to 6 months in the county jail, suspended on time served. That will be supervised probation as well. Count two, evading, 11 months and 29 days in the county jail, suspended to probation. That will be concurrent with docket number 19839.
Another charge in the case is resisting arrest, which falls under Tennessee Code Section 39-16-602. This law makes it illegal to intentionally prevent officers from making an arrest. But when charges stack up across several incidents like this, should courts prioritize rehabilitation through probation or impose stronger consequences to prevent future crimes?
In docket number 19841, count one, you're found guilty of evading arrest, a class D felony, sentenced to 4 years in Tennessee Department of Corrections. That will be suspended to supervised probation and will be served concurrently with the prior cases. Count one of 19842, count one, you're found guilty, sentenced to 2 years in Tennessee Department of Corrections. That will be also suspended to probation and concurrent for an effective 4-year sentence, if I'm reading this all correctly. And he'll be given pre-sentence jail credits. All remaining counts and case number 19838 are all dismissed as a part of the agreement. You'll need to see the probation department.
In the end, the judge accepts the plea agreement and gives the defendant multiple convictions but suspends the jail sentences to supervised probation, resulting in an effective 4-year probation sentence. This outcome follows plea procedures allowed under Tennessee Rule of Criminal Procedure 11, where negotiated pleas can resolve multiple cases at once. But here's the bigger question: did the judge make the right decision by allowing probation instead of prison time for repeated offenses like evading arrest? Or should someone with this many charges face stricter punishment? What do you think, fair resolution or too much leniency?